Mulder, and I will be attending the University of Nevada.
I'm Kaylee Connors. I'll be attending Northwestern Preparatory School.
I'm Lauren Pawnee, and I will be attending the University of Oregon.
And I'm Ben Besky, and I'll be attending the University of Nevada. Our unit coach is Mr. Scott Daniel, and our teacher is Mr. Richard Clark.
Great, well, nice to meet you. We will be doing question 1. So as soon as I'm done, you may begin. The Stored Communications Act of 1986 provides that government may demand the disclosure of some telecommunications records when specific and articulable facts show that there are reasonable grounds to believe that the contents of a wire or electronic communication, or the records or other information sought, are relevant and material to an ongoing criminal investigation. Under what circumstances, if any, should warrantless searches of electronically stored information on private and other non-governmental devices and servers be allowed? How has the court's interpretation of the Fourth Amendment changed since the Olmstead versus United States decision in 1928? And finally, does the warrantless search and seizure of cell phone records, which include the location and movements of cell phone users, violate the Fourth Amendment? Why or why not? You may begin.
Oliver Wendell Holmes stated in the Common Law that the life of the law is not logic, but experience. Paradoxically, it is often difficult to induce new legal logic from that experience. And as the evolution of privacy norms for electronic communication indicates, recent Fourth Amendment case law concerning third-party servers and the Stored Communications Act demonstrates that applying archaic concepts of privacy to electronic third parties does not adequately protect us from warrantless intrusion in those areas we have come to reasonably expect it. We instead favor a functional approach. We contend that any intrusion in any server or device storing data, whether by the person who owns it or by a third party reasonably performing the same function, constitutes a search requiring a warrant.
The roadmap for this development begins with the court's 5-4 decision in the 1928 case of Olmstead v. United States. This allowed for the warrantless wiretap of a voluntary phone conversation in one's own home because the sound traveled through wires outside of the house, so there was no physical intrusion. Justice Brandeis's dissent panned the majority for a failure of imagination, noting, "Ways may someday be developed by the government by which the government, without removing papers from secret drawers, can reproduce them in court, and by which it will be enabled to expose to a jury the most intimate occurrences of the home." A remarkably prescient application of the idea that the Fourth Amendment protects people, not places.
The court adopted Brandeis's approach in its landmark 1967 decision in Katz v. United States, ruling that by closing a telephone booth door, Katz is to have a reasonable expectation to privacy, thereby making the Fourth Amendment portable. Still, the right to privacy had outer limits. In the 1979 case, Smith v. Maryland, concerning a pen register of dialed phone numbers, the court established the third-party doctrine, stating a person has no legitimate expectation of privacy and information he voluntarily turns over to a third party.
Further still, the Smith decision demonstrates the problem of applying formal rules of privacy for landlines to the function of portable devices. In his concurrence in the 2012 case of U.S. v. Jones, Justice Samuel Alito laments that the court's holding of an affixed GPS tracker on a car constituted a search ironically applied 18th century tort law to a 21st century surveillance technique. Alito asserted that the court's inability to keep up with new technology may spur the enactment of legislation to protect against these intrusions. The Stored Communications Act of 1986 is one example of Congress providing more protection than the case law allows.
The Stored Communications Act is pertinent to the information of stored wire, electronic communications, and transactional records held by third-party internet service providers. When this bill was written in 1986, there was no way of predicting the future of technology. This invasion granted by a subpoena is a violation of one's privacy in the digital age. However, we have seen that in some circumstances, it is necessary to have exceptions, where the warrantless searches of electronically stored information is allowed.
In the current Supreme Court case, Carpenter v. U.S., the magistrate judge who issued the subpoenas in order to access the suspect's phone transaction history did so under USC 2703D. It is being argued by some justices, such as Sonia Sotomayor, that tracking a cell phone for 127 days through cell tower pings has become no different than a physical tracking system, making a violation of the Fourth Amendment.
In Warshak v. United States, the Sixth Circuit held that the government's use of Section 2703 of the Stored Communications Act to subpoena the defendant's unopened email on a third-party server constituted a search. The Stored Communication Act's reasonableness standard for a subpoena does not satisfy the probable cause and particularity requirement of the Fourth Amendment. However, the Warshak Court concluded that because the government relied on the Stored Communications Act in good faith, the email evidence was deemed admissible. This misapplication of the fact-based good faith exception to a question of law illustrates the need for new standards that make up for statutory deficiencies. Thank you.
So, on that point, you mentioned statutes quite a bit. I mean, say a little bit more about what Congress has done, I mean, since the Stored Communications Act, that you think is either good or bad when it comes to Americans' privacy.
One thing that was very recent is the Cloud Act was passed in the omnibus spending bill that was passed just recently. I believe that the omnibus or the Cloud Act is bad, not because the actual statute itself. It's the fact that the way it was passed is that the legislators and the congressmen added the Cloud Act to the omnibus spending bill at 8 p.m. the night before voting on page 2201 of the spending bill, which no senator can read in that amount of time. So there was not enough time to deliberate and have discussion on this bill because the senators their objective was to pass a spending bill, not the Cloud Act.
Sorry. Additionally, the Cloud Act allows for the president to enter into executive agreements. And these executive agreements allow for a little less leisurely than the mutual legal assistance treaties. And this allows for people to other countries to enter into these contracts where they don't have to necessarily apply for a warrant to get information on people. And it also requires for companies to enter in like 100%, not 100%, for the most part, give over their data.
And the reason the Cloud Act was passed was in conjunction with the United States v. Microsoft. The courts even said that it would be ideal for the legislators to come up with legislation to solve this issue because it was such a huge issue and they didn't know that they necessarily had all the information to solve it. But I do agree with my colleague that while the Cloud Act being passed was a good thing, it should have been an individual bill rather than in the spending bill.
Well, and a big reason why that was passed too is because the tech companies doing business in Europe and the US have to deal with both the privacy regimes there. Do you think that the way that Europe approaches privacy is better than the US?
I would argue, especially looking at Cambridge Analytica, we see that England, although they do handle it differently, they kind of go hand in hand. We still have the warrant requirement. We still have certain ways that we have to obtain that data. So in that sense, I believe we're one and the same in that aspect of privacy.
Building off my colleague, one of the bad parts about the Cloud Act is the fact that it gives the president the power to make these agreements. And it's not the agreement itself that is the problem. It's the agreement that it's the two-way street, that the country can also access their citizens' data that are living on US soil. And that's not a problem. The problem is the fact that when it comes to technology, usually when a person is accessing or has their data, it's usually connected to other people's as well, and that could be a US citizen.
So I want to build on that actually, because you mentioned in your prepared remarks that, unless I misunderstood, that some exceptions should still exist that would allow for warrantless searches, and I'm wondering what you think of the NSA's, monitoring cell phone communications, email communications in the name of national security.
So recently, back in December, there was a bomb threat at Pier 39 at San Francisco, and the reason how they found it is because this guy on Facebook was posting things and following terrorist groups and making terrorist remarks. In that sense, I believe the NSA was perfectly correct in following this data because they stopped what would have been a huge tragedy because they found this by going through his data on Facebook and his private messages.
Adding on to my colleague, I would argue that blanket searching of cell phone records and that just blanket surveillance is not in the interest of national security. Rather, when there are steps or when there is evidence that is showing that there is a possible threat, then taking steps to surveil that individual would be beneficial.
But aren't we always under threat? What if they say that's the only way we can find the terrorists, is blanket monitored?
We are under threat, however, the Fourth Amendment is in the Constitution. National security is not, and one of the key words in the Fourth Amendment is reasonableness. And I would like to argue that the reasonableness standard is not anywhere near a blanket search of all U.S. citizens, foreign nationals that enter the United States and the technology that they use.
Building off my colleague, in Carpenter v. U.S., Sonia Sotomayor stated in oral arguments, she referenced George Orwell's 1984 saying, "We don't want to be watched like Big Brother." we still have that right to be let alone, just like Brandeis said in his right to privacy article. So in that sense, I agree with my colleagues, we're not being watched all the time, but there are certain steps being taken where we need to step in and then monitor.
So you talked about third party and consent. So if I use my cell phone, I consent. I sign an agreement with Verizon. They seem to be here in the building as well. What about that? If I give consent, isn't that one of the warrant exceptions because I'm giving consent with these third parties?
You are signing over in a contract, you are agreeing to your contracts. However, in a sense, when you do agree to your contract, you don't have necessarily a say in what you're doing, because this is one of those where like you either take it or leave it contracts.
Additionally, with Facebook and Twitter, they have recently updated their privacy settings and now do a walkthrough of what their settings are in relation to the issues with Cambridge Analytica, and that is because many people do not read their contracts. They just hit I agree to terms and service because they are very long, and that is part of the issues. You are not fully informed when you're agreeing to this contract, so you don't have the knowledge of what is actually being done with your information, so it's not informed consent.
So you think one pop-up window from Facebook that says we may turn your Facebook account over to the government before you sign up, would that be enough? You don't have to.
Well, thank you very much. Round of applause. So I'll start with some comments. I thought this was really well done. A very good conversation here. I wish we could continue. Only 6 minutes, so short. I liked the structure of your opening statement. I mean, I love the life of the law quote. I mean, Oliver Wendell Holmes has a great quote starting off the whole thing, which I thought was appropriate given that you talked about some of the history, the older cases like Olmsted, you know, almost 100 years ago, and then now with modern technologies and cases like Carpenter. You got the big heavy hitters in there like Katz. You talked about the Smith versus Maryland case and the third party doctrine. And even got into some subtle points with Jones and talking about the Alito approach in that case as well. And you also mentioned U.S. v. Warshak too, the Sixth Circuit case, which you know, normally we might not expect you to talk about lower court cases, but in that case, that's a really important one and one that Congress is really following too. So it was really good to hear that stuff. And also, even with the Katz case too, the idea that, hey, it made the Fourth Amendment portable. I like the way that you put that, actually. That was nice. So, yeah, and I think, you know, I admit I threw you kind of a curveball with the Europe thing, but I mean, it's really tied into the Cloud Act, and you may have noticed recently that you're getting all these emails that say, we've updated our privacy policy, we've updated our privacy, and the reason why that's happening is because these European standards are coming into play with new privacy rules that, you know, Google and other companies that do worldwide business have to deal with. And so, I mean, one thing just to kind of, since I know you like this stuff, really look into that too, because there's a lot of, Europe and the US in some ways are going in totally different directions with privacy, and it'll be interesting to see how that resolves itself. But overall, I mean, I thought you did a very good job here, and we had a good conversation.
Agree. I thought you did well under pressure with the Europe question. It is something that, you know, the standards there are so much higher. But your command of the U.S. stuff, the stuff that the prompt asked you to answer, was really impressive. I really liked how you worked in taking actual positions on what the prompt was asking. You didn't just tell us the law and the jurisprudence. You told us, you know, how you think it ought to pan out and what you think it should be changed to apply to kind of today's real world, and I really enjoyed that conversation. I love that you brought in the Cloud Act. I love that you quoted Justice Sotomayor and the Carpenter opinion. That was really great, really well done.
It's kind of interesting. I think judging is probably just more rewarding than you guys being in the hot seat. But as I was sitting here listening to your points of view, it occurred to me that you're probably 17, 18-year-olds, and our whole lives changed September 11th with all the monitoring that has now come about through the Patriot Act and through this war on terrorism. It's interesting to hear your points of view because you were babies. We remember it probably like yesterday, but you guys, you know, you're living in this world where we're constantly being monitored for these reasons, and it's interesting. It's it's exciting and interesting to hear your opinions. It's always a good sign, I think, when the judges are asking questions and you're saved by the bell, because it means that we just want to continue to just pepper you and get your opinion. And when we ask difficult questions like Europe, it's because your depth of knowledge basically prompts us to. You know so much, you're citing like the actual page. I hope
Because you've read the whole thing.
Yeah, and then you actually listen to the oral argument on Carpenter. I'm like, oh my gosh, like, I hope that you're leading our country in the next decade. I think this is important for us. So give yourself another round of applause.